Hello and welcome to the course on Indian polity. So far, so good. We have discussed so much about the Indian Constitution, and finally, we are discussing the fundamental rights. And we have used the term state and the law repeatedly so many times. So, before we go in deeper, meaning of what does the state and what does the law mean, let us quickly recap what we have completed in the previous lecture. In the previous lecture, we have seen the different types of right, namely the constitutional right, the fundamental rights, the statutory and the legal rights. We have seen the differences in the positive and the negative fundamental rights. What were the properties of the fundamental right? Which are the rights available to Indian citizen exclusively? Which are the rights which are not guaranteed to the enemy? And what are the difference between the enemy alien and a friendly alien? And also, what are the fundamental rights which are available to the friendly aliens and are denied to the enemy aliens? Furthermore, we have seen the specifically Article 31A, 31B, and 31C, and we have discussed the privileges given under Article 31C to DPSP, namely under Article 39 subclause B and 39 subclause C, or the fundamental right under Article 14 and Article 19. So let us now today discuss the definition of the term state and the definition of the term law as per the Constitution under Article 12 and under Article 13. So the fundamental right, as we have seen, starts from Article number 12, and we have seen that the upcoming articles, that is from 14 onward, we will see there have been repeatedly mention of the term state. So it was right for the maker of the Constitution to define the term state in the very beginning, and therefore in the Article 412 itself, we have the definition of the state that we shall discuss today. So what you see on the screen is the snap taken from the Indian Constitution directly. And you see there is a term mentioned as the state shall not, and the state shall not discriminate over here as well. Then we have the state shall. So this term state has been used repeatedly in the coming articles. So in the very beginning article of the fundamental right, that is article number 12, we have the definition of the state, and it states that the article 12, the definition of the state, and it says that it includes number 1, the central government, number 2, the state government, and number 3, the local authorities. Local authorities means the municipalities, panchayat, district boards, improvement trust, zilla parishad, etc. So far we have clearly understood by reading article number 12 that state is not only limited to the central government. We have government at three level: at the central, at the state, and at the local level. So these government are basically what we are calling as the state. So we say that the state shall not, the state shall not. So it means that the central government or the state government or the local authority shall not do XYZ thing. So what if the tomorrow you are working in the government, you are a government officer, and you are working in the company which is owned by government? So whether then the company can make can pass some order that violates part third of the Indian Constitution, or that violates the fundamental right? What do you think? Whether a government company can pass some order, or it can pass some publication that, or provide some notification that violates the part third of the Indian Constitution, that is allowed? The answer to that will what the other authorities is is basically meant. So under Article 12, not only the central or the state or the local government, but we have the other authorities as well. And the term other authorities is not exhaustive, it is open to the interpretation of the court. And the court has interpreted that any organization which is under the control of the government, either the state government or the local government or the central government, or it has the ownership or it has some role to play, some stake in that company or organization, that will be also the part of the third state. That will be also counted under the domain of the state. That will be also considered as a state. So, if the company in which the government has some stake, if it is a government owned or government controlled company, so definitely it is coming under the definition of the term state. But whether what it has passed is not a law, it has not passed a law. What has it passed? It has passed an order. Whether the law was put before the parliament, no. So it is not a law, it is just an order. The management of the company has passed an order or has published a notification. That is not a law, that's what we are understanding as of now. So whether the company, which is a state, passes some order that violates the fundamental right, and is that true, or is that right thing, or is that does not come in contradiction to the constitution, or that is allowed from the point of the constitution, that what we are going to discuss in under article 13. If you are confused, let that confusion be with you. That will be cleared when we move on to article number 13. Before we do that, let us understand what are the other authorities are basically meaning under Article 12. So, namely, we have the LIC, ONGC, SAIL, Electricity Board, Public Sector Undertaking, Nationalized Bank, University established by the law, and which bodies are not considered as the state, the private companies, or the private unaided educational institutions, or the autonomous bodies without government control. In a single term, you can understand that any organization in which the government is having some ownership or some role or some stake can be considered as the state as per what? As per the other authorities that has been mentioned under Article 12 and has been interpreted by the various courts from time to time. So, as of now, the state not only includes the central government, state government, local government, but other authorities as well. And other authorities includes any organization controlled or owned or managed by the government of India or the government of the state or the local governments. Clear? Let us move to article number 13 and let us now clarify the confusion regarding to the order passed by the company. So before that, the Article 13, let us discuss Article 13, Clause 1 and Clause 2. Clause 1, we can we classify the laws into two major categories. One, the law that were passed before 1950, that is the law of the colonial era. And we are seeing that there are various laws of the colonial era that is still valid. And the major example of the is of what we call as the Indian Penal Code IPC and the Criminal Procedure Code CRPC. So there were laws that were passed before the implementation of the constitution. That is a separate point, that the laws could not be validated. There was no guidelines for the laws to be made, and therefore there was no validation of the laws. But after the constitution was enforced in 1950, you have some scope, you have some benchmark, you have something through which you can just compare whether the law is following what has been said in this book. So, the laws that were passed before 1950 and the laws that are going to be passed after 1950, and we are at 1950. That means the day in which the constitution is enforced. So, for the laws that are passed in 1950, let us just take a simple example to understand Article 13, subclause 1, in which let us say that there is a law which says that law regarding the allocation of land, for example, and this law is not just, it is totally against the guidelines of the Indian Constitution, specifically what has been mentioned under article under part third of the Indian Constitution, that is, it is violative of the fundamental rights. And we have seen that the law cannot be made that is inconsistent with the part third of the Indian Constitution. But this was the law passed before 1950. There was no constitution at that time, so it existed before 1950. And with this law being enforced, the land was allocated to person A, B, C, and D. Also, a law with some modification was made in the year 1951. That is after the enforcement of the constitution. Same law for the allocation of land, not that much or not directly violative of Part Third, but yes, in contradiction to the Part Third, and this law allocated the land to say P, Q, and R. This PQR may be a company or a person or something, whatever you want to suppose. Now, according to clause 13 clause A, where it is says that any law enforced before the constitution that is inconsistent with the fundamental right becomes void to the extent of inconsistency. It is basically meaning two things. The first thing is that if law that is existing before 1950, if it is violating of the fundamental rights, let's say suppose out of the 10 points of the law, 2 points are violative of the fundamental rights, then these 2 points shall be null and void. Not the entire law, only to the extent it is inconsistent with the part third of the Indian Constitution shall be termed as null and void. This is point number one. Point number two, the effect will be from 1950. That is not from the date in which the law was passed. So in our example, let's say suppose this law which was passed before 1950 has allocated the land to A, B, C, and D. So now all the law land that has been allocated to A, B, C, and D shall not be taken away because the law will become null and void only on in 1950. Before that it was valid and the law will remain valid. So the allocation of land that was done in the year before 1950 to A, B, C, and D will remain valid. But now from now onward, it will become invalid. And also to the extent of inconsistency, not the entire law, only those provisions which are inconsistent with the part third of the Indian Constitution shall be termed as null and void. And the effect will not be retrospective. That is not from the date of the enforcement of the law, but from 1950 onward. But now, and why is that so? Because before there was no guidelines. When did the guidelines come? The guidelines was enforced in 1950. So before you were unaware. So if you have made that law, okay, at that time it was valid, it will remain valid. Whatever changes that you have done under the purview of that law is valid. But now, from 1950 onward, that will become invalid to the extent of inconsistency. I hope that is clear. What does clause 2 says? Article 13 clause 2. It says that those, first of all, it prohibit that you should not make any law which abridges or take away the fundamental rights of the citizen. No law should be passed. But if you made a law and due to some reason the court does not took notice of that, and let's say few years after somebody filed a petition in the court and said that this law that was passed 2 years back is violative of the part third of the Indian Constitution, basically abridges or takes away the fundamental right, then the law will be struck down and the enforcement of the law will be declared null and void retrospectively. That is from the date when the law was passed. So if 1951 this law is passed and this law allotted the land to PQR, and in 1953 this law was declared as null and void, so all the allocation made under this law will be revoked. Because why? Because the law has been declared null and void from the very beginning it was enforced. Not from today onward, but from the very beginning it was enforced. So this is what called as the void ab initio. That means invalid from the very beginning. The law is invalid from the very beginning. So whatever action you have taken in the purview of this law shall declare as null and void. If you have allotted land to PQR in this law, since the law is become null and void 1951 itself, that is the day of enactment of this law, all the action made under this law will also become invalid. So the land allotted to PQR will also become invalid. That is the difference between Article 13, Clause 1 and Clause 2. Let us read that the state shall not make any law which takes or abridges fundamental right, and if it does, such a law is void ab initio, that is invalid from the beginning. I hope you understand the difference between the extent of inconsistency and void or invalid from the beginning. That is the difference between Article 13, Clause 1 and Clause 2 that you should understand. Clause 1 talks about pre-constitutional laws. Clause 2 talks about post-constitutional law. Obviously, post-constitutional law, you have already had the guidelines to make the law. And if you knowingly violates the guideline, then obviously that law will be termed as null and void from the very beginning of its implementation or enforcement. I hope that point is clear. Now let us come to the confusion point where we were talking about that company passes any order or notification. Will that be considered as invalid? The company we have already understood is under the what we call as the jurisdiction of the term state. That is, the company is the state. But what about the order or the notification? So clause 3 that is defines that. The Article 13 subclause 3 defines that the meaning of law. The term law includes, it clearly says what does the law includes. It includes ordinance passed by the president or the governor, which is not passed by the parliament, orders, okay, bylaws, rules, regulations, notifications, customs or uses having the force of law. All this thing. Now, who will pass the ordinance? It will pass by the president, not by the parliament. Who will pass the order? The state shall pass the order. Now, who is the state? Apart from the central state and the local government, we have seen the other authorities also are the state. That is any organization controlled by the government, that is the central state or the local government is also the state. So if they pass some order which is violative of the part third of the constitution, that is violative or abridges or takes away a fundamental right, that will be also invalid. So I hope clause after reading Article 13 subclause 3, you will be that means clause 3, Article 13 clause 3, you will be very clear of what does the state and what does the law mean. The law means the ordinances, not only the law passed by the parliament or the legislature, but also the ordinances, orders, bylaws, rules, regulations, and notifications. What about the constitutional amendment? I hope at this point you must recall that video where we have discussed sufficiently at length about the Article 13 clause 4, wherein we have talked about the various judgment of the court, where we have discussed about whether the constitutional amendment is considered as the law or not. If it is not considered as a law, that means it can violate the fundamental law because fundamental rights, because Article 13 subclause 2 only talks about the law shall not make any law. What shall not, who shall not make any law? Talks about that state shall not make any law. And law, Article 13 subclause 3 defines these things, and this thing does not include constitutional amendment. So do we or can we by constitutional amendment takes the fundamental right of a citizen? And that was the question or the challenge before the Supreme Court. And under various judgment, it has taken a different stance. But finally, the court agreed that yes, the constitutional amendment is also taken under the jurisdiction of the term law. And tomorrow, no parliament or no government can amend the constitution and takes away the fundamental right, because yes, the constitutional amendment is also coming under the jurisdiction of the term law. So originally, it was unclear whether the constitutional amendment were law under Article 13 or not. So the judgment under the Shankari Prasad 1951, it said that the amendments are not law. If the amendments are not law, that clearly gives the power to the parliament to change the fundamental rights by making an amendment to the constitution. But in the Golaknath case, it says that the amendments specifically means law. That means the amendments is equal to the law, and the parliament cannot abridge fundamental rights, because if amendment is law, then the parliament, if it changes the amend or if it amends the constitution, it will come in violation of Article 13 clause 2. And Keshwananda Bharati judgment also reiterates the Golaknath case and says that Parliament can amend any part of the Constitution, including the fundamental right, but cannot alter the basic structure of the Constitution. And in the basic structure, it defines the fundamental right as well as the judicial review, based on which we have seen in Minreve Mills 1980 case, where it says that the constitutional amendments are valid as long as they do not violate the basic structure. I hope Article 13 and 12 are not that much complex to understand. What were the important points in it? I have already explained in detail. So now we are ready to move ahead with the first, that is the article which is directly related to the fundamental rights in part 3 of the Constitution, that is Article number 14. So moving forward to the Article number 14, Article number 14 says that equality before the law and equal protection of the law. So it says that the state, now we have understood, state shall not deny any person equality before the law or the equal protection of the law. Why I have highlighted these terms? I have highlighted this term because the term state we have already discussed. Any person. What do you mean by any person? Any person means whether the state, any person means the biological person. No, it means any legal person. What we are talking here about, legal person. And what do we call as a legal person? Of course, that also includes the statutory bodies, that is the bodies made under the law, statutory bodies, and corporate as well, corporations as well. So the state shall not deny not only the individual biological men or women or the citizen, but also the statutory bodies and the corporations, which is called as the legal person. What it shall not deny? It shall not deny, number one, equality before the law. Equality before the law. That is what point number one of Article 14 says. Equality before the law. As a layman, we clearly understand that equality before the law means everybody is equal in front of the law. That is, when you are in the court will treat common man as well as a rich man equal. The laws will not discriminate between rich or poor or between the MLA or a common person. So everybody is treated equally before the law. Better understand, let me give you some example. For example, if I am an IAS and I take a bribe, or I am a or say I am a clerk and I take a bribe, the punishment what is given to an IAS for taking a bribe of say rupees 1000 is same as to what a clerk will get for taking the same amount of bribe. So there is an equal punishment given to both the IAS as well as the clerk. It is the law is not differentiating that you are an IAS, you will be given a lesser punishment. He is a clerk, he will be giving a higher punishment. The state shall not discriminate. So the before the eyes of the law, everybody is equal. What we understand by this equality before the law. Another example, for example, let's say suppose I am an MLA and I want to register a case in the police station. I'll also have to file an FIR, first information report, in the police station for my case to get registered. The process that anybody that is also a common man have to follow is same. He will also, the common man will also go and ask a police officer to register his complaint, to register an FIR. So the process is same whether you are an MLA or you are a man or you are a woman or you are a common ordinary man or you are rich or poor. There is no differentiating between the citizen. There is everybody before the law are equal. Obviously, there are some exceptions. Leave aside that. We will take that in the later part. But as of now, what as a layman we can understand that yes, if there is a law, the law should treat every citizen equally. Okay. After that, whether the domain of equality before the law is only this much, that is, no person is above the law, everybody is equal in front of the law, there is no advantage or privileges is given to anyone, every citizen or every subject or every person is subjected to the ordinary law and ordinary courts. There is no special court for anyone else for the violation of the or the breach of the law or for the plea or for petition. Everybody has the door of the courts are open for everyone, whether you are rich, poor, whether you are an MLA or you are an MP or you are a common man. So, is this the only definition of equality before the law? Not that. So, what else? The interpretation is what we get in the case of E.P. Rayappa. So, the E.P. Rayappa was an IAS. He was a senior IAS officer. E.P. Rayappa, he was a senior IAS officer and he was serving in the state of Tamil Nadu. And being a senior IAS officer, he was serving in a position of chief secretary. Chief secretary. And the year was 1971-72, and there was a political change. After the election, the government changes, and the new government, what it does, it transferred E.P. Royappa out of the post of chief secretary, and deputed him as deputy chairman of State Planning Commission, SPC. Now, an order has been passed in which E.P. Royappa was transferred. He was changed, given a different post. He was earlier serving as a chief secretary, and now he has been made as the deputy chairman of the State Planning Commission. So, E.P. Royappa, being an IS officer, it was like it appears that the order is unjust, was like made randomly, and it was based on the political motive, not like on the merit. The order was not based on the merit, it was on the political motive. So EP Royappa went to the Supreme Court. The year was 1974, and what Supreme Court observed is remarkable to the interpretation of the Article 14, that is equality before the law. The Supreme Court stated, and I quote you, that the arbitrariness, arbitrariness, arbitrariness is the antithesis of equality. Antithesis of equality. If tomorrow there is a question on what do you mean by the equality before the law, you can quote this. That the Supreme Court in E.P. Royappa 1974 judgment said that arbitrariness is the antithesis of equality. That is, equality is not just about a reasonable classification. Kindly note it down that equality is not just about reasonable classification. You can quote this in essay as well. Equality also means the state must act fairly, reasonably, and without arbitrariness. And without arbitrariness. Any arbitrary, that is, any random, arbitrary, or we say random, unfair, or irrational. I hope you are able to read while I'm writing. Irrational action by the state violates Article 14, that is equality before the law. So now it is very clear that equality before the law does not only means the absence of the advantages to some citizen, that is, the law will be made and applicable to all its citizens without any discrimination. It also means that the law should not be arbitrary. It should not be random or unfair or irrational. It should be rational because arbitrariness is the antithesis of equality. So now, the equality before the law also include that the law should be fair, just, and rational. It should not be random. So this is what the Supreme Court made out of the term equality before the law in the EP Ropaya, sorry, Royappa, very sorry, EP Royappa Judgment 1974. Now, there should be some sort of question coming to your mind. So, if I am speaking about that the law should be equal, everybody should be treated equal before the law, then why we have that those who are above 18 years of age will only vote? Is this not discrimination on the basis of age? If I'm not 18, you're not allowing me to vote. The moment I become 18, you are allowing me to vote. So why there is a different law applicable to a different section of the people, that is above 18 is treated differently by the law? And yet just before this moment we have said that the law is equal before every citizen is equal before the law. So there is a slight what I say is thin difference between these two statements. Let me make it very clear for you. But before that, let me give you three more examples. If you are, if you see the income tax slab, we have that there are different slabs. That if you are earning ranges from A to B, you will pay 5%. If you are ranging between B to C, you will pay 10%. If you are ranging from C to D, you will pay 20%. These are the income tax slab. So under the Income Tax Act, why is such difference is created? The law should treat everyone equal. So why it is treating A and B, the citizen lying under the category A B will only give 5% tax? Why the citizen who are earning in the range B to C will give 10%? So is it not arbitrary? Is it not the discrimination based on the earning? So why is it allowed? Why the voting is allowed above the age of 18? Why do we have different tax slab for the different earning capacity of the citizen? Yet we are talking about the equality before the law. So equality before the law is valid here also. Why? Because if you see those citizens who are in A and B, for all those citizens, the law is same 5%. For all the citizens whose income is in the range B and C are have to pay 10%. For all these citizens who are earning in the range C to D, are the law is same for 20%. For all the citizens above 18 years of age, the law is same. They can vote. For all the citizens below 18 years of age, the law is same. That is they will not be able to vote. But there is classification. There is a classification that is being made. So before we discuss on what ground this classification is made, let us just complete what do you mean by the equality before the law. Then we will go to the next part that is called as the equal protection of the law. This is the part second, that is the equal protection of the law. So when we discuss the equality before the law, it is a negative concept and taken from the British origin. Why taken from the British origin? Because the British origin because in British there was a judge named as the A.V. Dicey, and it is said that the concept of equality before the law is an element of the concept of rule of law. The rule of law was propounded by A.V. Dicey. And who was A.V. Dicey? A.V. Dicey was a British jurist, and therefore we say that the equality before the law is nothing but it is of British origin, that is taken from the rule of law that was propounded by A.V. Dicey. And since he was a British jurist, we say that equality before the law is of British origin. So, what does the rule of law say? The rule of law said, number one, absence of arbitrary power. So, in in the British or in the Great Britain, what we have is the supremacy of the Parliament. That is, the Parliament is supreme, not the Constitution. That means if I am a citizen, I am free to do whatever I want to do unless and until I am in contradiction with the law. And whatever the laws has been made, whatever the right has been granted to me, and who has granted me the right? The Parliament. Whatever the laws, the right that the Parliament has granted shall become the Constitution. What is the Constitution in Britain? the laws that are passed by the parliament is supreme, and that is the constitution. It is not that, as in terms of India, we say that the constitution is enacted, there is a book, and the laws are made keeping the book in the mind that the law should not violate the part third of the Indian constitution. But in Britain, whatever laws is being made, whether it is just, fair, unfair, don't care about it, it becomes the constitution. It is a part of the constitution. So you are free to do anything you want to do, unless and until you are in contradiction with the law passed by the parliament. So the parliament is supreme, not the constitution. But the Avid he propounded the rule of law. He said, yes, if you are free to make law, that means you can make any law because there is no constitution, there is no prohibition on you. No, that is not the case. There should be the rule of law. And the rule of law, it says that there should be absence of arbitrary power. That is, no man can be punished except for the breach of law. You cannot punish any man except for the breach of the law. Then, equality before the law. That is, the equal subjection of all the citizens. Then the third point is the primacy of the rights of the individual. That is, the constitution is the result of the rights of the individual as defined and enforced by the court, by the courts or law, code of law, rather than the constitution being the source of individual right. So in India, the constitution is the source of the individual right. And in Britain, constitution is not the source of the individual right. It is the law is the source of the individual right, and laws are basically enforced passed by the parliament and enforced by the court. So this point of the rule of law is not been taken under the equality before the law. Only these 2 points, that is absence of arbitrary power, that we have seen in the EP Royappa case, where it has been said that arbitrariness is also violation of Article 14, and equality before the law, which is what we have seen in the Article 14. So tomorrow, if somebody asks you whether the equality before the law is of British origin, yes. Whether it has been taken from the Avid theory of the rule of law, yes. Not all the part, some part. Which part not taken? The part which says that the constitution, or it is not the constitution that is the source of the a citizen's right, but it is the law that is enforced by the court. So that part is not the part of the equality before the law, is the part of the rule of the law, not the equality before the law. So equality before the law is a negative concept, is taken from the British origin, and no person is above the law, no special privileges for anyone. Everyone is equally subjected to the ordinary law and ordinary code, and emphasize absence of arbitrary behavior of the state. All this point we have discussed. So now, what we're talking about, why we have the legislation for different categories or for the different groups of people. We have seen above in the example that for the people 18 above 18 years of age, we have a different legislation. For this group of people, we have different legislation. Why is that allowed? So before you make laws for a group of people, treating them different, you have to ensure three things. Basically, you ask the question yourself: why you are treating the group of people differently? Is there any basis for treating this group of people differently? Is the different the difference that you are making between these two groups, for example, above 18 years of age and below 18 years of age, is logical and not arbitrary? If you are ensuring this thing, first of all, you have to identify why you are treating this group differently, and whether the reason that you have identified is logical, reasonable, and not arbitrary. If that is the case, then you are allowed to do so. And why you are allowed to do so? Because Article 14 says that there should be the equal protection of law. And this is what the equal protection of law means. So, equal protection of law is basically a positive concept and taken from the American origin. Like person is in similar circumstances should be treated like. Like person in a similar circumstances, that means if you are 18 year of age, should be treated alike. That means it does not allow class legislation, different rules for the different class of people, but it allows reasonable classification. That means it allows the state to treat different groups of people differently if intelligible reason exists. Now if you see, isn't it very vague that I am saying that you can, on one hand, I am saying that yes, everybody is equal before the law. And then in the very second statement, I'm making a statement that you can make different laws for different group of people based on if you are grouping the people, if you are classifying the people, the reason of the classification is just, it is reasonable. Is it not very vague? Who is there to decide that whether the classification done is reasonable or not? Yes, of course, the court. The court is there to see whether the classification or whether the grouping of people for which you are making the laws are reasonable or not. And is there any arbitrary parameters on which the reasonable classification will be decided? No. There is also the test defined to test whether the grouping or the classification is reasonable or not. So two points, two things that should be very clear at this point. Number one, everybody is equal before the law. That means everybody within the group is equal before the law. A person 18 below the 18 year of age, if a law is made for them, every citizen who are below the 18 years of age are equal before the law, because they will be judged by a law, and every citizen of that category will be judged by that law, that will be equal before the law. But there could be the different laws for the different categories of the people, for the different groups of people. That is what we call as the equal protection of the law. So, for examination point of view, you can write all this point that it is a positive concept taken from the American origin, and a like person in similar circumstances should be treated alike. But for your MCQs, you should understand the logic behind it. Now, we say that the different groups of the people, for example, there are some citizen, you classify this citizen as three groups. You made three groups. Now, if these three groups, the grouping, the basis on which you have made this group is reasonably well, it is just, it is rational, then you can make a legislation for this group. But if it is unjust, that could not be allowed. So, what are the parameters on which we can test reasonable classification? It is 2 point. Number one, intelligible differentia. That is, the differentiation that you are making should be intelligible. The reason should be intelligible. The criteria should be intelligible. And the second is the rational nexus. These 2 points you should remember and can mention in your answers. Number one is intelligible differentia. What does it mean? It means that a reasonable basis for grouping people or things which distinguishes them from others for the purpose of law. That means you are making law for different groups of people, and the law should be justified. The classification that is the grouping should be reasonable. Then only, and the law, obviously you are having some objectives to meet. You want that this group of people have certain objective, and which is different, entirely different from the another group. So you are making two different laws for these two groups, so that the objective of these two groups, which are entirely different from one another, should fulfill. If that is the case, you qualify the intelligible differential test. The second is the rational nexus. That is, there must be a logical connection between the classification and objective of the law. So, for example, I have given you the example that is, there is a reservation criteria, there is a tax rate based on the income, then we have the separate law for the women, we have separate law based on for the children, for the adult, for the adolescents. Then we have the Juvenile Justice Act. There are so many Maternity Benefit Act which qualifies under Article 14. So I hope you are now clear what does the equality before the law means and what does the equal protection of the law means. Now we say that there is some exception to the equality before the law. You cannot treat everyone equal before the law, and whom you cannot treat the equal before the law is what we call as the exception. And where do we get this exception? These exceptions are also mentioned in some way in the constitution, which we are not going to do right now on that part. But since we are doing article 14, so it is very fair enough, go with the exception also, but the articles are from the other parts, so that part we will see later. And when we go to that part, we will also see the things that we are seeing over here, but it is right to discuss the exception here itself. So the first The first exception is what we get under the Article 361 of the Indian Constitution that says that the President of India and the Governor of the state enjoys following immunities. And what are the immunities they enjoy? The President or the Governor is not answerable to any court for the exercise and performance of power and duties of his office. Obviously, the President is the first citizen of the country, so he should be given some priority. So that what the first exception under Article 361 is that they are not answerable to the any court for the exercise and performance of the powers and duties of his office. Office means while the term he is serving as the president of the government. Point number two, no criminal proceeding shall be instituted or continued against the president or the governor in court during his terms of office. That means if you committed a crime, even though no criminal proceeding shall be instituted, shall be initiated against you. Why? Because you are president and this post is very respectable. So, in order to maintain the dignity of this post, so tomorrow in the newspaper, if it is out that the president of India is charged of rape, he is charged of murder, so whether is it the individual that is getting targeted or the president of the country is getting targeted? It is the post, the position. So in order to maintain the dignity of the post or the position, no criminal proceeding, that is the governor and the president has been giving immunity, that is no criminal proceeding shall be instituted as long as he is serving as the president or the governor. If you want to initiate a criminal proceeding against him, ask him to resign or impeach him, and then only you treat him as a normal citizen, and then the equality before the law is applicable to him. Point number third, no process of arrest or imprisonment of the president or the governor shall be issued from any court during his term of office. Cannot arrest him while he is serving as the president or the as a governor. No civil proceeding against the president of the governor shall be instituted during his term of office in any court in respect of any act done by him, even in his personal capacity, whether before or after entered upon his office, until the expiry of 2 months next after the notice has been delivered to him. So, whatever, if I am president, whatever I do, point number one, understand simple language. I am a president, whatever I do as a president, whatever I do as a governor, I shall not be answerable to any court. Nobody, no court can call and question me why you have done this, why you have done that. Second, no criminal case can be initiated against me as I am serving as a president or the governor. Third, no police can arrest me. No court can issue arrest warrant against me if I am serving as a president or a governor. Point number four, if I have done something wrong, even in my personal capacity, and you want to initiate a civil proceeding against me, then you have to give me notice. You have to give me a 2 month notice, 2 month notice, and within 2 months, suppose if I have a civil dispute with my neighbor in my personal capacity, you have to give a 2 month notice to me that after 2 months, a civil case will be initiated against you. Why this 2 month notice? So within this 2 month, I may be able to settle the dispute. I may convince my neighbor or with whom I am having a civil dispute. We'll try to settle the dispute before the court only. So that is why with the 2 month notice shall be given before you initiate a civil proceeding. So criminal proceeding, no, not at all. Civil, yes, but for that you have to wait for 2 months after giving a notice to the governor or the president. That is what the immunity is being provided under Article 361. Then under Article 361A, the immunity is also given to the any person who publishes any report or now in any social media or any media or via any source. So far and so long, the report or the publication made is true, is correct for the related to the procedures or the proceeding of either house of the parliament or either house of the legislature, he shall not be liable to any civil or criminal proceeding. Let us read it for you. No person shall be liable to any civil or criminal proceeding in court in respect of the publication in newspaper or by radio or television or by substantially true report. The report must be true. If you publish any of the proceeding of any of the house of the like the parliament or the state legislature, and if that publication is true, then nobody can instigate or initiate any civil or criminal proceeding against you. Substantially true report of any proceeding of either house of the parliament or either house of the legislature of the state, and that is what mentioned under Article 361A. Then the immunity to the members of parliament under Article 105, very important. Article is also important. We will go through it also when we cover the parliament section of the Indian Constitution. So the third immunity is given to the member of the parliament. It says that he will not be liable to any proceeding in the court in respect of anything said or any vote given by him in any parliament or any committee thereof. I am an MP, I can speak anything in the parliament. So, whatever I say, even if it is defamatory or derogatory or comes in contradiction to any law, if I violate any law, I shall not be called into the court. I shall, or no, means no proceeding against me can be initiated in any court because that thing I have said where, not in the public space that instigated a fight between the people, but I have said that thing in the parliament and I am free to speak anything in the parliament and nobody can drag me to the any court for what I have said in the parliament or to any vote that I have given in the parliament. That is the immunity given to the member of parliament. That is also an exception to Article 14. Also, no member of the legislature. Now, here we have the parliament. The no member of the legislature of the state shall be liable to any proceeding in any court in any respect to anything said or any vote given by him in the legislature or committee thereof. Article 194. Then Article 31C, already we have seen that is if you even if a law made that violates Article 14 and Article 19 to enforce 39 clause B, 39 clause C shall not be declared as null and void. That is also an exception to Article 14. Also, the foreign sovereign, that is the people working in the embassies and the diplomats, that enjoys the immunity from the criminal and the civil procedure. Also, the UNO and its agency enjoys the diplomatic immunity. So, to summarize, you can say number one, the immunity is given to the president, then it is given to the governor, then it is given to the MP and MLA, then it is given to the diplomats, foreign diplomats, not Indian diplomats, foreign diplomats, let's say foreign sovereign, foreign sovereign, and the United Nations Organization and its agencies. Just remember, number one, president, number two, governor, number three, MP, number four, MLA, number five, foreign sovereign, and number six, UN. President and governor, all the details we have discussed, just remember that. MP and MLA, for whatever he has said in the house of either parliament or state legislature and vote given by him, and foreign sovereign and United Nations Organization and its agency. So that is all but we have to discuss in Article 14. Now we will end this video over here and further in the next lecture we will be starting with article number 15 and try to complete article 15, 16, 17 and article number 18. I hope you enjoyed the lecture and thank you very much for having patience and watching this entire duration. We will meet in the next lecture. Till then, revise what we have discussed and have good luck for preparation for examination. Thank you.